Oh, sorry. I'll be talking without you hearing me. My mic was off. Sorry about that. So good afternoon. I said we have 40 students and it's a reasonable number to start. So we are discussing two related questions this afternoon. So the first, they're all from land law. The first has to do with to what extent does the Land Act 2020, Act 1036 provides panacea to problems and dissatisfaction that landowners encountered during compulsory acquisition, or when the state triggered the doctrine of eminent domain. Then the other question has to do with this quote: the construction of National Cathedral on land previously acquired compulsorily by the state, the construction of bungalows for government officials has reopened the issue of returning land compulsorily acquired back to the original owners. Critically comment on this issue. Yeah, so as you will notice, the two questions are all related, and they have to deal with compulsory acquisition or the doctrine of the eminent domain. Yeah, so first, as we discussed yesterday, how to properly structure your answer. So let's start with the very first question. I think the question is pretty straightforward, and we have no doubts concerning what the question is asking us to do. Can somebody tell us in his own words his or her understanding of this question? Yes, anybody? If you don't want to be discussive, I'll just talk to you and go, okay? All right, so.
Hello, sir.
Yes, Moses. Is it? No, no, Vinny.
Yes, so what I know is that since we had a compulsory acquisition, landowners have been encountering some issues, especially in respect of the fact that their lands are taken many times. There's delay in the payment of compensation and all the matters arising. And so I think that the question is asking us to what extent the new Land Act has put in provisions which before the time wasn't there to enhance the proper way of going about acquisition so that it would benefit, or at least it would resolve the problem that was existing before the time in respect of compulsory acquisition. So that should be the question. And so we have to be looking at the Land Act and the new things perhaps it has introduced to beef up the process to make it better, especially for landowners. That's my understanding of the question.
All right. Okay, all right. I think that is good, Vinny, pretty straightforward. Yes, good. Yeah, so to do a good response to a question like this, of course, you ought to have studied compulsory acquisition. So there are some topics in land law which I will say that you have to learn. You have to learn your leases, okay? You have to learn your leases. Maybe in our subsequent sessions, we will pick one or two questions around leases. You have to learn your leases well. You have to know your compulsory acquisition. Of course, we talk about the customary interest in land. especially, you need to be able to tell us whether the Land Act has affected customary land law interests. In what ways? It is important you know the changes which have been made to the law by the coming into force of Act 1036, that is the Land Act, that is important. And again, there's an area to which students often don't learn. That is what we call the land title registration and registration of instruments, okay, affecting land. So these two are important because when we have to discuss to what extent, for example, has the Land Act also provided solution to problems confronting those who buy land, and this phenomenon of multiple sale and other dishonest dealings in relation to land transaction. You need to know those things to be able to actually do justice to the question. And of course, if you are also discussing issues of adverse possessions and all that, as to whether the particular land there have been registration and there's a land title in relation to that, as opposed to just ordinary instrument, all those things will make significant difference. So I've just given you, if you like, a bird's eye view of areas, if you haven't studied so far in land law, you have to look at. Okay, good, but we are looking at compulsory acquisition now, so let's focus on that. So before we come to this question, we come and discuss the question. Before we come to this question, we have to understand that compulsory acquisition, also known as the doctrine of eminent domain, is an interference by the state with the property rights of the citizenry or individuals. Of course, if you go to the Constitution 1992, I think Article 20 of the Constitution, it protects the right to property, and at the same time, it also provides the parameters within which compulsory acquisition may be done. Of course, being a state, the state does not have a land of its own, apart from lands which were taken over by the state during the colonial era. All other lands are compulsorily acquired as and when there's a need for it. And the state will compulsorily acquire where it is needed for public interest, the public purpose. But you notice that the case of the Okujetua Blakwa and then the Obichebi Otanka Lamte, and as well as the case of the Ni Obi Sru III, all Supreme Court decision, the issue of what really amounts to public interest, public purpose, for which reason the state may compulsorily acquire a land belonging to someone came up, if you remember. And of course, the interpretation of the Supreme Court, which has not changed ever since, is that where the state actually stated a particular purpose as being the basis for the compulsory acquisition of a relevant parcel of land belonging to a citizen, nothing prevents the state subsequently, if it decides to use it for other purposes, so long as those purposes are for the public. So that let's say that if the state acquired the land, said that it was going to use it to build a public university, but it never did that. And after a while, the state decides to use it to build something like maybe a museum, right? The museum is for the public purpose. It's something which will near to the benefit of the public or section of the public, as Justice Duce indicated in the need through the third case. And also Justice Brobe would also follow it in the Okujetua Blakwa and then the Jacob Chebilamte's case. So let us keep that in mind. If you haven't looked at those two cases, just look at it, especially the relevant portion on the public purpose. Good. So having known that, the other point to remember is that we have to look at Section 233, right? Section 233 of Act 1036, that's the Land Act, which makes the point that, or it confirms the power of the state to compulsorily acquire a land where the land is necessary for a public purpose, as we've endeavored to explain, and in the interest of defense, public safety, public order, public morality, public health, town and country planning, resettlement purposes, or for the running of essential services, or for road construction, or any road-related infrastructure like bridge, canal, and so on. And also, in order to secure development of that land in a manner that promotes the public benefit. So the emphasis here is whether it promotes the public benefit. But of course, for the first two categories, there's no dispute about the public dimension. If you say that you're acquiring it in order to safeguard public safety, public order, public morality, and so on. So someone may wonder, under what circumstances may the state have to compulsorily acquire land for the sake of the safeguarding public morality, as it were? Well, it may well be that there's a private property somewhere which is being used for seriously immoral and to the detriment of public morality, and to enable the state to probably monitor it, it may be necessary to be close to it, and that may mean that it's compulsorily either taking over that particular facility or taking over a nearby facility. I mean, this is just an extreme illustration. But the point about Section 233 is that the power of eminent domain, the power of compulsory acquisition is emphasized. And we know some of the grounds or some of the purposes, the basis for which this power may be triggered. So let us keep that in mind. But in order to ensure that this power is not abused, the use of it is circumscribed. Compulsory acquisition cannot just be done anyhow. So if you look at 233 subsection 2, for example, the necessity for the acquisition must be clearly stated, and a reasonable justification for causing any hardship that may result to a person who has interest or right in that should also be stated. So that is the high threshold which should be met. So it's not just the case that the government wants to compulsorily acquire something and then it is just that. No. Don't forget that government is manned by human beings. So if you don't have some of these parameters, if I hate you and I come to power, I'll just make use of the eminent domain and compulsorily come and acquire your house, as it were. And that is why the law is that the necessity, and the necessity here will have to be one of the three broad categories of reasons that we have looked at. That would be like the necessity for the compulsory acquisition. And of course, since the land which is being compulsorily acquired previously belonged to someone, someone has got property interests. And if we go back to the social contract theories, which attempts to justify the existence of a state and the exercise of state power over individuals and the citizenry. One of the reasons, especially if you are following the John Locke's version of social contract theory, is that the state exists in order to protect the property, among other things, property rights of the citizen. So I have submitted to the authority of the state in the sure hope that the state is going to protect my property. I've not submitted to the state for the state to be depriving me of my property, to do what we call expropriation, right? To strip me of my property rights and take it. And that is why, if the state should deem it necessary for the public purpose, in the public interest and all that, to take over my property, then the state is supposed to compensate me. So if you look at Article 20 of the Constitution, as well as Section 233 of the Land Act 2020, Act 1036, it is a requirement that the state makes a prompt payment of fair and adequate compensation before compulsory acquisition can be done. So the emphasis is fair, prompt, adequate. So all these are very important. That is to say that there should be no delay in payment of the compensation. It's not the case that you compulsorily acquire my property and then it takes 2, 3 years, 5 years before the compensation will come. And then the fairness here means that we have to actually ensure that the compensation will go to the one whose property is taken. It's not the case that you compulsorily acquire something and you pay the compensation to somebody else. And also, we come to quantum of the compensation, that is the adequacy. And as you look at the whole of Chapter 7 of Act 1036, that is the Land Act, you notice that part of the process, the procedure for compulsory acquisition is what we call the valuation, right? At some point, valuation will have to be done in order to arrive at fair assessment of the compensation. That is to say that you get a rare sense, a rare idea of how much the property is worth, so that you are able to determine the quantum of the compensation. So if you look at the section 258, you can just make a note. And if you haven't read the whole Chapter 7, I will encourage you that if you intend to answer a question on compulsory acquisition and you haven't read the whole of Chapter 7, you haven't read the case that I have mentioned too, then you haven't prepared properly on compulsory acquisition. But if you read the whole of Chapter 7, right, of the Act 1036, which is not, it's not lengthy, just from, it's not lengthy, something that we can easily just get it done, just from section 233 to section 267. So just a few provisions, just about 12 pages or something. You can just read it a couple of times. And then you read these two cases that I mentioned. There are a lot of cases, but if you read these two, I mean, that should suffice. Yeah, so so the compulsory acquisition here, we must be familiar with like the processes, like the procedure, okay? So the procedure will include the publication of the EI, executive instrument in the Gazette, in which the government will have to specify the nature, extent, and location of land and the purpose of the acquisition. So that should be published first, that the government intends to compulsorily acquire land 5 acres on the Spinters Road, Dodua Road, or a flower area, or a Tonsu area, or Takrady, or wherever, just name it. And the purpose should also be stated. Is it going to be used for manufacturing? Is it going to be used for this, going to be used for that? It should be stated. And then it is gazetted. The purpose of gazetting it is to let the public be aware, and especially those whose interests are going to be what? Affected. And please, I would like you to pay attention to section 239, okay? So section 239, if you look at the sessional subheading, it says compulsory acquisition procedure. So the procedure for the compulsory acquisition is governed by section 239. Section 239 will make cross-reference to section 240 to 249. So the whole of section 240 to 249 will give you like the breakdown of what is needed or the processes that must be gone through in order to have compulsory acquisition. So 240 will essentially make the point that we made when we were looking at the opening provision of section 233. So section 240 will make the point that yes, if the state decides to compulsorily acquire, it must make a declaration in a form which has been prescribed. So a form has actually been designed for that purpose, which will be used by the state to do that. And once that is done, it should be published in the Gazette. Just in case you've forgotten what the Gazette is. Gazette is simply official publication by which the state communicate to the citizen, by which the state communicate to the world, so to speak. So that if something is put in the Gazette, it is presumed that everyone is aware of it. And it's part of the foundation for the legal maxim. The ignorance of the law is no excuse, because if you go to Article 106 of the Constitution, part of the procedure for making law, passing a bill into law, will include gazetting it. So therefore, once it is gazetted, the assumption is that everyone knows it. Good. Yeah, so section 240, as I said that the declaration should be gazetted. And then once that is done, it may well be that maybe the declaration is done and the government probably has a change of mind and it does not go ahead immediately to kickstart the process. So if you look at section 242, it makes the point that where a declaration of intention to compulsorily acquire has been made, it shall lapse and cease to be of any effect on the expiry of 2 years. So when the declaration is made and the process does not go through and 2 years elapses, that declaration will no longer be effective. And all proceedings which have been taken or in consequence upon that will have to actually come to an end. But the exception is that where the government has made like maybe like a declaration and of intention to acquire particular property and stated the purpose is gazetted. But it happens that there's a litigation between some citizens concerning that property. Now, that will definitely put the compulsory acquisition sometimes on hold because we need to know the rightful owner so that when assessment of the compensation is made. If he has any objection, he can go to court and then get the objection addressed and all that. And also, who should be paid the compulsory acquisition. So where there's a litigation, then that will actually put some hold. Otherwise, if 2 years elapse and nothing is done, that will actually mean that that declaration of intention is no longer applicable. But then if you look at the 240 again, it makes a concession that the Lands Commission may, for good cause, before the expiry of the 2-year period or within the time that the court may allow, apply to the court for an extension of the period, and the court may extend the period for a further 1 year only. Okay, so where a declaration has been made, as we have indicated, but for some reasons, the compulsory acquisition process has not made progress, and the government, through the Lands Commission, would like to get more time. It can go to court for extension of time, and the court can grant not more than 1 year. So let us keep that in mind. Now, the next thing to note in terms of the procedure is what we call preliminary investigation. Preliminary investigation will have to be done. And if you look at section 241, it's quite explicit on what that entails. That where the state has come to the conclusion, or the state has made up its mind that any particular land anywhere is required for public purpose, the Lands Commission, which represents the state in this case, will now appoint a staff or an official to go to the particular land and do certain inquiries, do certain investigation. And these include make a survey and take levels of that land and adjoining lands within the locality. Then you take part of the soil for soil analysis. And then you also undertake valuation of that land. So valuation of that land will be like the, what you call, especially the surface rights, the things which are already on the land, people's farms, crops, or other developments. You have to do all that as part of the preliminary investigation. And also take any practical measure needed to enable the compulsory acquisition to go ahead. And it may also entail marking out boundaries, okay? Like marking out boundaries so that we have a clear idea of the exact parcel of land, which is going to be the subject matter of the compulsory acquisition. So let us keep that in mind. The other step, which is also important, is notice to a person with interest. Notice to a person with interest. Don't forget that we have said that the state should make the declaration in the Gazette, okay, to let people know. So if you look at the section 242, where the state has decided to acquire the land, like through the compulsory acquisition, as we have indicated, and the requisite notice as contained in Form 2 has been given by the Lands Commission. If you go to like the 5th schedule, that is at the end of the legislation. If you go to the 5th schedule there, at page 210, if you have the hard copy, you notice that there's a special form which is designed. Notice to person with interest of intention of compulsory acquisition of land. So this form will be sent to any person who claims to have an interest in the subject land of compulsory acquisition. So the state itself, through the Lands Commission, will have to be proactive. And that is why the preliminary investigation is important, because part of the preliminary investigation under Section 241 will help the officials of the Lands Commission to know those who have got interest in the relevant land. So the formal notice will have to be given to them, as we have indicated. And the notice is also supposed to be published at least once in the Gazette and a daily newspaper of a national circulation. And a copy shall also be posted on the notice board of the district assembly and then the particular traditional council. And a conspicuous copy is also supposed to be put at the particular land, which is going to be compulsorily acquired, as it were. And all these are meant to help people with interest in the land to come out and bring up any concerns that they may have, as it was. So let's keep that in mind. Another step within the compulsory acquisition process or the procedure is demarcation, surveying, and entry of the land on the register. So once the notice has been given to those who are supposed to have interest in the land, the Lands Commission under Section 243 is required to cause the areas affected or to be affected by the compulsory acquisition to be demarcated and surveyed properly. And of course, if there has been survey already, then there's a survey maps or plans will be taken. In absence of that, you have like a fresh survey. And a note of the intended compulsory acquisition will be indicated in the land register or the deeds register. So as soon as the survey and the demarcations are done, then the Lands Commission will have to put a red flag in the land register. You know, we talk about two things, land register and deeds register. And I've told you that it's part of the topics that we have to learn. The land register here is in relation to how to call the land title registration, okay? And then the deeds register is in relation to instruments affecting land. So you have indenture, you have lease, you have the statutory declaration and all that. All these are instruments affecting land, and that they will have to be registered and what you call like the deeds register. But then where a land has actually gone through the the processes of letting it be entered in the land title registry, then we have like the register called the lands register. That one contains the actual interest and the names of the true proprietor. Whereas the deeds register is just a register for documents relating to interest in land. And those documents do not necessarily validate ownership. But the land register actually validates ownership. So let's keep that in mind. And that is why there will be a talk about the indivisibility of title and so on. But that was just a digression. So let's come back. So part of the process of the compulsory acquisition, as I said, the survey is done, demarcation is done, then the necessary entries are made in the land register. That is where the land falls within a registration district. That is a place which has already been processed for purposes of a land title registration scheme. Or if the land is outside an area which has gone through land title registration, then it is just the deed register which will be relevant, and the information will be taken over there. The next step within the compulsory acquisition is what we call consultation with stakeholders. Stakeholders should be consulted. That is, those who have got interests in land to be compulsorily acquired. And not only owners, also those who are also occupying it. So both the proprietors and also occupiers, they are part of the stakeholders. So a meeting will have to be held with them, or some engagement will have to be conducted. It is expected that regulations will be made under this law in the form of LI to provide a framework for how the consultation shall be done. So at the end of the consultations, a report is supposed to be prepared and then published by the Lands Commission in respect of the compensation of the consultation. And the report, which is so made, will have to be forwarded to the relevant traditional authority and district assembly. That is the particular area, the district assembly in the particular area which is going to be compulsorily acquired, as well as the traditional authority, that is the chiefs, the paramount chief and all that around there who constitute the traditional authority. They will have to be given copies of the report which emanated from the consultation between the Lands Commission and those who have interest in the area to be compulsorily acquired, as it were. So let us keep that in mind. Of course, if at the end of the consultation, there's a need to have further survey, like more work to be done in order to iron out maybe certain differences which came up during the consultation, that will be done by the officials of the Lands Commission. Now, what happens if the state, before we come to the compensation bits, let's look at the other scenario. The states decide to make a withdrawal from the acquisition. Now that is possible. The state can make a withdrawal from the acquisition, notwithstanding the declaration of intention it made when it published the notice, and same was what was gazetted. So in the same way, if the state is withdrawing, the state will have to use the same route it used to declare its intention to acquire. So the state will also have to publish a notice that it is no longer going to compulsorily acquire the land it had previously earmarked for acquisition. So let's keep that in mind. And sometimes the withdrawal by the state may have to be in consultation with the people affected. Maybe you have the stakeholders, and if we look at section 247, maybe at the end of the meeting with the stakeholders, certain issues come up, and then the state say that, okay, I can't go ahead and compulsorily acquire if some inconveniences have been caused or some damages have been occasioned to you. Because don't forget that as part of the compulsory acquisition, there will have to be preliminary investigation. The preliminary investigation means that Land Commission officials can go onto the land by authority of this legislation and do all manner of things. And some of the things that they do may actually interfere with the surface rights of the occupiers. So if you decide not to go ahead with the compulsory acquisition, you've created problems for us. Because if the compulsory acquisition was going to go ahead, we will get compensation. So we are not worried. But if it's not going ahead, there's no opportunity to get a compensation. So those damage or those inconveniences costs, they may have to be paid by the state. If the state decide to withdraw from the acquisition as it were. Now we come to the compensation bit. Let's look at the compensation bit. But maybe before that, I think there's something I should draw your attention to in terms of where the compulsory acquisition process has started, and people who have interest in the land to be compulsorily acquired have to come forward, register their concerns and all that. So the one important question is that who can come forward? So I want you to pay attention to section 250. Section 250, which was about those who can make claims. So a person who claims a right or interest in land, that is a subject matter of compulsory acquisition, shall within a period not exceeding 6 months from the date of the publication of the executive instrument, submit in writing particulars or information about the claim or the interest that he has in that particular land, and also indicate how his interest has been affected by the compulsory acquisition executive instrument, and also indicate the amount of compensation which he is claiming, and not just say anything. You must provide basis for calculation of the compensation. Just before we started the class, when I was late, I was in a certain meeting online with some institution somewhere concerning some negligence matter, trying to settle it. And the person who is looking for the compensation had just quoted a huge amount of money, but he or she does not provide explanation as to how he or she should be given that huge compensation. So that's the kind of thing that the law is trying to avoid. So you said that your interest in the land to be compulsorily acquired is affected by the compulsory acquisition instrument. Good. So you want compensation. State how much, and then explain the basis for the calculation of the compensation. So who can make such a claim? If you look at section 250, subsection 2, 7 category of persons or interest holders have been listed. So if you are the holder of the alluded title in respect of the land to be compulsorily acquired, you can step forward and make a claim in the way explained, or you are holder of a customary law freehold, or you have a common law freehold, or you have the usufructuary interest, a leasehold interest, customary interest, tenancy, or any other interest or right in relation to the land. Of course, when you mention leasehold interest, you should also know that if you are a sublease, right, you have a sublease, you are also part of it, because all the various derivatives of the leasehold will be applicable. Despite the fact that the reversionary interest under the sublease will go to the lessor, as it were. And any other interest in relation to the land, you can go forward and make a claim and also ask for compensation, but you need to justify the compensation as we have actually indicated earlier on. Now we come to the assessment of the compensation. How is compensation supposed to be assessed? Well, we have already talked about the fact that notice will have to be given to people whose interests are affected by the proposed compulsory acquisition. And after that has been done, the Lands Commission is required by Section 252 to give notice of assessment using Form 3 in the 5th schedule. So if you go to the 5th schedule, Form 3 is there. So the commission is supposed to send that to those who are supposed to actually come forward and get their compensation determined and paid. So the Form 3 is a very simple document. And so the notice of assessment, and then the particular place is stated, it goes on like that. Now how do we actually compute the compensation? The valuation will be done, and the valuation will be done to determine the market value. The market value, which will help to determine the quantum of the compensation. There could be misunderstanding regarding the compensation to be paid. Where there's misunderstanding, you don't rush to court. You are supposed to make use of ADR. So the Alternative Dispute Resolution Act, 2010 Act 798, is supposed to be used before you go to court. Although you can ultimately go to the High Court, but it is encouraged that if there's opportunity for you to sit down with the Lands Commission and get the issue of compensation trashed out, that should be done. But more importantly, there are certain factors which must be taken into account in an attempt to determine the compensation. And I'd like you to pay attention to Section 256 of Act 1036 and be familiar with those factors. And these factors are any improvement to the property of the claimant as a result of the acquisition. So the acquisition is definitely going to may raise the value of the property, so that will have to be taken into account. And why is that important? Those neighboring properties, they are going to benefit from the enhanced value of their property, just because maybe the state has decided to do a certain physical development there, and overnight the property is going to appreciate. And for that matter, if your land happens to be the one being compulsorily acquired, you're also entitled to be compensated for, because you are going to lose that land for good, whereas your neighbors are rather going to gain in value by reason of the particular development which the state is going to do there. So that is why 256 say that should be factored into computation of the compensation. And then any damage sustained or likely to sustain by the claimant as a result of the acquisition. Then see any damage sustained or likely to sustain by the claimant by reason of the acquisition adversely affecting the other property of the claimant or in any other manner. Then D, the need of the claimant to change residence or place of business. So sometimes there's what they call the relocation, right, or resettlement. You do compulsory acquisition, and those who are affected may have to be moved to a completely new places. Just like if you take like the Bui Dam construction, people who were affected, they have to completely resettle in a new settlement. So that is a kind of thing which is anticipated. And then another factor is the undertaking by the state, person or corporation on whose behalf the acquisition is made to construct roads, drains, walls, fences, or provide other facilities benefiting any part of the land left unacquired. So it's not just paying money. There may also have to be some other consequential infrastructural developments. And all those things will have to be factored into the compensation. Because if those developments are going to be done, then it will definitely affect the quantum of compensation. Otherwise, you end up creating the scenario of what you call unjust what? Enrichment. And then, resettlement of a displaced claimant on a suitable alternative land. So all these are supposed to be taken into account. But as I said, the bottom line is that the compensation should be fair and also adequate. It should be fair and adequate. And that is why valuation is actually important. Now, how is the assessed compensation actually disbursed? How is the money paid out? I would like you to look at section 259. A formula is provided regarding disbursement of the compulsory acquisition compensation. So if you look at 259, where the compensation is assessed in respect of land, where its statutory interest exists, the disbursement is as follows. 60% goes to the holder of the statutory interest, and then 40% to the holder of the allodia title. But where there is no statutory interest, then it will be paid to the holder of the allodia title or the holder of the freehold interest, as it were. And again, where the land, which is compulsorily acquired, is subject matter of a tenancy, then as between the holder of the allodia title or the freehold interest and customary tenant, the compensation shall be paid subject to the following: 60% to the holder of the allodia or freehold interest holder, and 40% to the customary tenant. Or as between the holder of allodia title, the holder of his statutory interest and customary tenant, the compensation payable for the land shall be 40% to the holder of the allodia title, 30% to the holder of the statutory interest, and 30% to the customary tenant. So finally, a new addition to the law is that an escrow account is supposed to be open. When we say an escrow account, that is to say that a special purpose account is supposed to be set up in which the money earmarked for payment of the compensation will have to be lodged in by the Lands Commission, or if a compulsory acquisition is being made on behalf of a particular company or corporation or institution, the sponsoring institution or the sponsoring corporation will have to make the amount of money needed for paying the compensation available to the state through the Lands Commission to be lodged in the escrow account. And not until the money is lodged in the escrow account, the compulsory acquisition cannot actually proceed. So look at section 260 of Act 1036. Yeah, good. So I have given you some information to help you think through our two questions, just in case you've not been reading that part of the law. So having said that, what are the points which will go into question one? What are the points? Let's just list them. What are the points which will go into question one? To what extent does the Land Act 2020 Act 1036 provide panacea to problems and dissatisfaction that landowners encountered during compulsory acquisition, or when the state triggered the doctrine of eminent domain. So, yes. What are some of them? Yes, Julieta.
My Lord, good evening.
Good evening.
Yeah, please, Per, the question you've posted, I think first of all, in our introduction, we have to talk about what compulsory acquisition is, in stating Article 20, and also Section 233 under the Chapter 7 of Act 1036.
Okay, that's good. What else?
My Lord,
yes.
Can I continue, please?
Yes,
please. So after that, then after we talk about our introduction, stating what compulsory acquisition is per the Constitution, and then Act 1036, we talk about some challenges, or in the introduction, we'll talk about instances where the state can compulsorily acquire land, and then we talk about the procedure. That is from Section 240. We talk about the procedure. Then we talk about the compensations. Then we also talk about instances where the claimants can come forward to raise their concerns.
Okay, Julieta, well done. But I think, of course, and I know you are just listing the points. That is good. So after the introduction, I think the question is straightforward. So instead of maybe talking about if you like the procedure, okay, before you come to talk about like the problems and the solution, there may be some repetition, because the problems and the solution are actually built into the procedure. So we'll do ourselves some good if we can identify some of the problems, right? Identify some of the problems or challenges which confronted the landowners in the pre-Act 1036. So problems pre-Act 1036. That is to say that before the Land Act was passed, of course, we had the Article 20 of the Constitution, but as you will notice, Article 20 of the Constitution is not detailed enough, and there are a lot of questions which are not addressed there. So Act 1036 now will come to expand things. So now we want to know what were some of the problems which landowners will encounter prior to Act 1036. And then you will try to show how the regime for compulsory acquisition in Act 1036 has actually overcome these problems, or some of them, as it were. But basically, that is what the question is. And as I said, once you have some case law, you need to also let it reflect. Let it reflect in your answer. Okay, now, because of time, let's take the second one, and then we have to call it a day. So the construction of the National Cathedral on land previously acquired compulsorily by the state for construction of bungalows, for government officials has reopened the issue of returning land compulsorily acquired back to the original owners. Critically comment on this issue. Yes, any trial? And it's also pretty straightforward. How will you go about that? when we finish that, and there are some people who have questions in the chat. I'll address them before we end. Yes.
Hello, my lord.
Yes, Moses.
Okay, my lord. Thank you very much for the opportunity. So for this question, I remember when we started the class, you did mention that when the state decide to compulsorily acquire the land of a family or a stool or whatever interest that it holds, that the state wants to acquire, the state would have to actually provide reasons for the acquisition and what it intends to actually use the land for. And for which these two, we mentioned these two cases, the case involving Jacobiche Bilampe and Okujeto Ablakwa, and then the Nichuru, which we try and say that once the state is not going to use for the purpose for which it acquired the property, then the state has to return it to the owners. But then the Supreme Court held that whatever the situation is, if the state is not going to use, the state did not use it even for its intended purpose, but even used it for another purpose, which still is in the public interest, then it means that the state can still lay claim on this compulsory acquisition and not necessarily have to give back the land to its owner. So coming back to the question that the land was actually acquired for the purpose of construction of bungalows, and now it has turned to building, how do you call it, this cathedral. We can say that for the building of the cathedral is also one of the issues that could be considered as something of public interest. So for that reason, we can say that if the state is not going to use the land for its intended purpose for which it acquired it, the landowners should come back and say that they really want to get back their land. This is how I would want to tackle it, my lord.
All right, thank you. Yeah, yes, thank you.
Hello.
Yes, any other?
Hello, sir.
Yes.
Yes, sir.
Yes, sir. I think the main issue of the question is on Article 26, where it provides that if the state compulsorily acquire a land and having provided the purpose for acquisition of the land, then where the state no longer use the land or need it for that purpose, then the original owners should be given the first right of refusal. And so the issue is, at what point will you say that particular use is no longer for the public purpose or for...
Yes, go ahead.
The issue then is, at what point will one say that the land so acquired by the state is no longer being used for the public purpose or for the purpose for which it was acquired?
Right.
Then we look at the case in Okujato and Omanabuama versus Jacob Lanten, Attorney General, where the Supreme Court ruled that where the land is being used and the public will have access to it, then it still suffices as a public purpose. And so the right of refusal by the original owner does not come in. The right of refusal by the original owner only comes in where the state does not need the land at all. But if the state is giving the land to a developer to utilize it for the public interest, then the original owners are not given the right of refusal. So the National Cathedral particularly is built by the state and for public purpose, the public will have access to it. In that case, it's still in sync with Article 20. And so the original owners cannot claim to wanting to have right of to acquire it back. Thank you, sir.
All right, thank you. Yeah.
Hello, sir.
Yes.
Please, I want to address particularly the issue about the National Cathedral, because we know that it has gone to court, Bonfe v. the Republic or the AG, where they went and talked about the fact that the state's participation in the building of the cathedral is discriminatory and all that. And there, the Supreme Court said that looking at the unity between the state and religions and all that, it was necessary for the public interest, and for which reason they gave, if you like, life to what they were doing, that it wasn't wrong for the state to participate in something that would improve, since there have been that collaboration between the state and religion. And so, and they even talked about the fact that none of the religions has also gone to seek any help from the state that the state has not given. And for that reason, it described, if you like, the building of the National Cathedral as something that was important for the public interest. And so, because of that, for this question, for example, then we will say that with regard to the discussions that we have had about the need for compensation and all of these things that we have said, and in regard to Okujato Ablakwa, the Obichebi Lamte, where they talked about the fact that the public interest is not just about the very purpose for which it was acquired, but also any incidental thing, then I think that it would tie in with the Bonfe case to say that lands, indeed, when lands are acquired by the state and they are being used for the state interest, whether the one that was very said or any incidental, then that should go on. But when some are acquired and have failed to be given compensation, even those owners have died and all of those things, and people are trespassing on these lands, then I think that is where we have to deal with it, to say that then there's a point to give back the lands to. Thank you. That's my contribution.
Thank you very much for your contribution. Okay, so I think
Your Lordship,
you've done justice. Yes.
Yes, Your Lordship. I want, if you look at the question, we are looking at public interest. So what constitutes public interest? And who determines public interest? And how will we know, we the citizens, how will we know that this is the public interest, so that we are guided by that?
No, but the cases that we've cited, and the Bonfe case that our friend has cited, they give us understanding of what public interest. And also, if you look at the Constitution itself, the interpretive clause, I think the 2.9, I don't have my Constitution with me, but you go to like the latter part. Public interest, I think, is defined there as something which inures to the whole of the people of Ghana, or a section of the public of the people of Ghana. And if you look at the Justice Doche's opinion, is in the through the third case, he also expatiated on it. Now, coming back to your question as to who determines the public interest, I think that is why we have political authority. So every 4 years, the citizens will elect a group of people to be in charge of the state. So long as they have been elected to office, they determine every point in time what the public interest is, except that there are parameters. You cannot just say something is public interest if objectively it cannot be demonstrated to be inuring to the benefit of either the totality of the Ghanaian population or a segment of it, as it were. Okay, so there's somebody has a question. Can a person or group, for instance, in the case of family land, refuse to yield to compulsory acquisition? I think having gone through our discussion earlier, I'm sure you know the answer now, isn't it? Compulsory acquisition, as the word suggests, compulsory, okay? The government does not need consent of anybody before it can go ahead. All that the law, the constitution, and the act seeks to do is to ensure that the fairness is actually followed. We compensate in a manner which is fair, adequate, and prompt. But we don't need consent of the landowner. Otherwise, it will be counter-productive to the idea of compulsory what? It's compulsory. Compulsory means that we are doing it against your will, except that we want to compensate you for that which we are doing against your will. I think that's it. Is there any other question? Yeah, I think that's all. Okay, so I think we've exhausted the question. Unless there's something really, really major which we haven't talked about in relation to this issue we are discussing, in which case will let us know. Otherwise, we will draw the curtain down tonight. Okay, so have a good night.